So good evening, friends. Welcome back to my series on the subject of economic and corporate laws for the CA final course. And in the next three class, I'm going to cover one of the recent laws which have been introduced in our country and in the limelight of all the corporate world, that is Insolvency and Bankruptcy Code 2016. This law, which has been introduced only 6 years back, 6 to 7 years back, has caught the attention of the lawmakers, the corporate world, the adjudicating authorities, and common people like us, because we are also affected by this code. How we are affected, and what should be taken care of. And as a professional, as a future chartered accountant, what should we look into in this particular law? I think very promising law, and with a lot of opportunities also for chartered accountant in this world. Myself being an insolvency professional, I've been practicing in this area. I can vouch for that. Yes, there have been a lot of changes in my working as a professional, and a lot of opportunities have come across in this particular field. So let us begin with this particular code, and I hope students must have joined in. Just to let me know who are the people who have joined in. Can you send a message on the message box so that I can understand people who have joined in? So an exciting law, a different law with a different perspective. So let's jump into it, because it has different parts. So I'll be covering in three lectures, where in the first two lectures, I'll be covering the theoretical concepts and along with few questions also. And then we'll be covering the smaller aspects in the last part, along with case studies. So why there was a need of this law? Wasn't something in existence before this law came into picture? Was there any law which was talking about insolvency? So the answer is yes. There were few laws which were talking about insolvency, and those laws were framed quite long back, especially with respect to individual insolvency. And there were few laws which were introduced by our government, but they had certain limitations. But more importantly, the need of the law came into existence, or the purpose was that when you look from a business perspective, as a businessman, we are all excited to start a business, and there's a lot of energy in starting a business. And when we think of closing a business, we always feel that how can we close a business? Or is closing a business an easy process or not? So government have taken a lot of steps in easing the process of starting a business. There are a lot of promotions done by the government, where if you want to start a business, then there is a single day clearance, one window clearance, 1-person company, and so on. So starting a business had been made very easy. But the government thought, yes, if we have made starting a business very easy process, why not closing down a business also should be an easy process? So then they felt, yes, there should be some law which should allow people to close down a business under various situations. And that is why this need came in to bring in a law which could, ease down the process, make laws more customer friendly or user friendly, or the people, stakeholders friendly, and ensure that things go in a proper way. So if you understand the concept of ease of doing business, I think this is one of the major indexes which actually ranks a country. So India's ranking has considerably improved once this law was introduced in 2016. And you can see now that India is in the top 50 positions of ease of doing business index created worldwide. Because now the whole cycle of business, from entry to doing a business and closing a business, is now streamlined. So that whole cycle is now getting completed, which was not earlier there. Though it was there, but then the process of closing down a business was a painful process, a cumbersome process where it took years to close down a business. Now that has been cut down to a particular time frame, obviously subject to all the litigation. But yes, we all now understand that closing a business is now getting easier in India also. So that whole cycle of business is now complete. From a businessman perspective, from an entrepreneur perspective, I think it's very important to know that yes, entry and exit should be easy. It's not only about doing an entry, but the whole process should be easy. And that is why this law came into existence. So the features of this code, which talks about various important features, it's a comprehensive law. When I say comprehensive, it covers all aspects of insolvency, be it individual, be it corporate, be it partnership firm, anyone who is doing business in whatever form, it has covered every aspect of business. And there's no multiplicity of laws. That means we don't need to look at different laws to close down my business. So under one framework of IBC, I can follow the steps and close down my business instead of knocking doors at different level, different places, different laws, and different codes. Now there's only one single way. One window clearance, that is the NCLT, that is the adjudicating authority, which will give all the clearances for my actions. So that itself gives an weightage to the whole process that I don't need to run here and there. One chain of authority, which is IBBI, which is the regulatory authority, and there's no such multiple authorities as there's no multiplicity of laws. The two important aspect is always the low time resolution, which was not in existence previously to this law, which means that the average time period to close down a business was more than 5 to 7 years. Now, imagine a person who wants to close down a business has to run at different levels for 5 to 7 years, and then only he could close down a business, which was a difficult job. But yes, now within this framework, the whole process is reduced to some time period. But yes, obviously within the litigation, within the framework of law, it does take time. But yes, I think not 5 to 7 years, but it has been considerably reduced. And there's always a concern. There's always a concern about taking care of all the workmen, the people who are working at the shop floor level, and the laborers. And this law actually takes care of all the interest of the workmen. When we'll review that, we'll understand, yes, this law is taking the interest of the workmen and the employees. So we have Janvi, Mancha, Purnima, Viraj. Viraj, I saw previous batch recorded first lecture. Okay, good. Great. So let us move ahead and understand what this law talks about. The overriding effect is, Mancha, it's not about only use of technology. Ease of doing business is not about only technology. Technology only facilitates the process, but law should be framed where I can do my business easily. So development of MCA website or income tax website or GST and network, these are all indicators, but the basic premise is the law. So the laws should be there, then only we can understand the ease of doing business. Technology is only an enabler. So when this law came into existence, there were a few laws which became redundant. That was the CICA Act, which was earlier there, and the Presidency Towns Insolvency Act 1909, which talks about, did talk about individual insolvency and so on. So they have become redundant. And there were amendments in 10 central acts, right from income tax to the Companies Act and various other acts. So a lot of acts were amended and few of the acts were repealed. One of the most important features of this particular law is the overriding effect of Section 238. And that 238 talks about that this law will prevail over all other law for the time being in force. That means if any other law talks something else which is in contrast to whatever is mentioned in this particular code, then this law will prevail over that other law, which makes it very strong, which gives it an upper hand in most of the situation, though there have been certain legal legal cases where some other laws have been given certain preference, but that is subject to certain facts and circumstances only. But in general, this law has become very super powerful because of this Section 238, which gives them the overriding power. So remember, 238 section, one of the major sections of this, or that though that section is very small, which only states that it has got an overriding effect, overriding power over the other laws remaining, which are currently prevailing in the country. But yes, because by virtue of this law, we get so much of relief and concession and freedom from other laws. That means we are not subject to other laws when this process of insolvency is carried on. Now, generally speaking, friends, when we talk of insolvency, though we all understand insolvency is a negative term, but this act is not a negative act. That means we should look at this act from a positive framework of mind. 238 is section number, Mr. Viraj. Section 238 of IBC, that has an overriding effect, which gives power to this particular IBC Act, which states that the provision of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time in force. Yes, so I was talking about the word insolvency and the understanding of the term insolvency, which should not be looked into from the negative point of view. It should be more of a positive aspect. Why I'm saying that? Because, see, insolvency should be considered as a state. Very important. So, when we talk of insolvency, remember, when we talk of insolvency with respect to individual, it is known as bankruptcy. And when we talk in terms of organization or corporate, that is known as a corporate insolvency. So, it's just a state of a business or a person where he is not able to pay the debt, or the value of assets are not enough to pay off the liabilities. So this is a particular state. Now we all understand, if it's a state, it's a current state, that state can be resolved. That state can be passed over by certain mechanism, by applying certain steps. And we can pass over that particular state of that particular individual or company and come out of that state. That's a possibility. And this IBC code provides for that possibility, that how can we come out of that state where the company can come out from insolvency. Obviously, there has to be certain pain which has to be borne by some people, those who are involved with the company. But yes, there could be a possibility that this whole process, this whole state can be resolved. So when we talk of this whole code IBC, please understand it has to be looked at from a positive framework of mind. We need to understand this IBC code provides a solution for a problem. It provides a solution for a problem. It is not creating a problem. So solution for a particular state which the company or an individual can pass through anytime. It can happen with anyone. Remember, it can happen with anyone because of ABC conditions. And we all know that those ABC conditions, some may be in control of that particular person. And because of his indecision or wrong decision, he has fallen to the state of insolvency. But there are certain stages or events which are not under our control. And because of those events, I go into insolvency. So there could be certain market related events for which I'm not responsible. But then market had taken those steps, government has taken some steps, or nature has taken some steps, because of which I have fallen under this particular state. So if there's a state of insolvency, if it is treated, the treatment can be done through a resolution plan and recovery for a corporate. And for non-corporate, it will be through a repayment plan. It will be through a repayment plan. Remember, so this is important thing which we need to understand: resolution plan and repayment plan. So resolution plan is certain document. Remember, it's a document which is validated, accepted, approved by the court, and which actually a document which will contain a list of steps which are taken to treat insolvency. And that document, if prepared for a corporate insolvency, it is known as the resolution plan, which will talk about that, how will I resolve this company, whoever proposes this resolution plan. And for an individual or partnership firm, it is in the form of a repayment plan. And ultimately, in both the cases, the recovery will be made through the resolution plan for all the stakeholders. What are the provisions for willful defaulters? Which provisions? Mancha, I'm not clear. But yes, willful defaulter are covered somewhere in this particular act under section 29A, but I'm not clear what is the question. So if insolvency, if it is not treated, if they cannot come out with a resolution plan, if they cannot come out with a repayment plan, then it will lead to bankruptcy. Then we can say that that person is a bankrupt, or the company would be liquidated. And then once it is liquidated, that means company is closed down and the existence of the company is over. So bankruptcy and liquidation is a step or a stage when insolvency could not be treated, when there is no resolution for that particular stage of insolvency. But if it is resolved, then there will be no need of bankruptcy or liquidation. So these are broader things which we need to understand before we actually take a plunge into the technical or the legal part of the law. So it should be very clear in mind. We should have that holistic understanding of this act, that what does this act talks about. So remember, insolvency is a state, bankruptcy is a conclusion, or liquidation is a conclusion. That's the final stage. Under this act, the final stage would be liquidation. And after liquidation, the closure of the company. So there will be two parts in this particular law. One is the resolution part. And if no resolution happens, then the liquidation part or the bankruptcy. So we'll talk in two stages. One stage is the resolution. Second stage is the liquidation stage. So if we go to the preamble and the objectives, the whole objective is intended to strike the right balance to all the stakeholders of the business enterprise so that the corporate and other business enjoy the availability of credit and at the same time the creditor do not bear the loss on account of default. What does this mean? It simply means that once insolvency starts, then the state of that company should remain as it is on the insolvency commencement date. That means if the company is running, let the company run once it is admitted in insolvency. There should not be any step to stop the operations of the company. So we should try to ensure that the business, the balance of the stakeholders or the interest of the stakeholders is maintained and they continue to do the business operation. So the whole objective, as we have discussed, is to consolidate, amend the laws related to reorganization in insolvency resolution of corporate person. As we have mentioned that few of the laws have been amended and all the laws now come under one banner, one roof, that is IBC. We have a fixed time period for bringing out a resolution or liquidation. There's a time-bound manner where the whole process has to be completed. Then we need to maximize the value of assets of the interested person. That is obviously one of the objectives. Now, fourth and fifth point is something which is very contradictory at times. Why it should promote entrepreneurship? I mean, on the one hand, we are talking about insolvency, and on the other hand, we'll talk about entrepreneurship. How is it correlated? So, friends, as an entrepreneur, if you look from the entrepreneur's perspective, we have something in mind, as I discussed in the initial part, where he feels comfortable that entry and exit should be easy. Running a business is obviously my job, but giving me permission and closing down the business, and for that, if I need permission, that should be easy. Rest to ensure that I run my business well, that is my responsibility. So when he thinks that, yes, opening and closing is easy, and the government is providing you a platform where you can compete and run your business, then I feel that I should start doing my own business. So that is why this law is taken as an integral part, where we think that, yes, it is promoting entrepreneurship because it is giving certain relax or a certain framework where people would feel relaxed that, yes, I can close down my business easily. Yes, Mancha, a resolution plan is a type of a turnaround plan or the whole restructuring of business. To increase the availability of credit, yes, friends, when the company goes under insolvency, we all know that if any person goes towards insolvency, nobody would give him loan because that is already insolvent. But once the company comes under this IBC code and is admitted towards insolvency, then raising money is not a major problem. Raising money would not be a major problem. Then there are provisions in that act which will ensure that, yes, the company can raise funds even after being admitted towards insolvency. And there are provisions which will safeguard the interest of the lenders who lend money to the company which is under insolvency. So there are a lot of provisions. So that is why there is an increased availability of credit. And to balance all the interests of the stakeholders, including alteration in the order of priority of payment to the government dues, to a certain extent, government dues have taken a hit because of changes in the payment structure or the waterfall mechanism, which we are going to discuss in due course under Section 53, which is one of the major sections of this particular code. So under that waterfall mechanism, government dues, they fall at a later stage. And then we have the one board which has been created, IBBI, regulatory agency for all the companies under insolvency. So if you see the framework, yes, yes, Mancha, we'll discuss on that voluntary liquidation also. We'll discuss that. Janvi, the interested person is obviously all the people. I mean, even the business owner and the creditors, both are interested person. The creditors, obviously, they want their money back. And the business owner would also like to ensure that the business runs well so that maximum value could be generated so that he does not bear a lot of pain, maybe because he has given a personal guarantee or his assets are mortgaged to the bank. So his interest is also affected. So he's also an interested person. Okay, so the framework IBC code, we have two framework. One is the IBBI and second is the adjudicating authority. IBBI and adjudicating authority. IBBI is the regulatory agency for all the people who are involved in this whole process. And adjudicative authority, that is the court, that is NCLT, to decide on all the legal matters falling under this particular code. So under adjudicative authority, we have the tribunal, and thereafter we have the Supreme Court. Even in tribunal, there is the NCLT and the appellate tribunal NCLAT, both. NCLT and appellate tribunal, both. And under IBBI, we have three: IPA, IP, and IU. So who are IPAs, who are IPs, what are IU, and what is the function and role of each? Let us understand that. So these are the framework, the pillars of IBC code. So when you have multiple pillars, you can understand the effect, the people involved, the coverage of the whole code, and the stakes involved of so many people. So let us start with the regulatory agency IBBI, which was established as a regulator, and obviously the office is at New Delhi. It's a body corporate, same as SEBI. So it has got the chairman of the board, and there are a lot of people involved who work for IBBI. That means it's a government-owned regulatory agency, which has got different legislative, executive, and quasi-judicial functions. So they have got certain legal powers, judicial powers, where they can take action against different people, penalize them, and it's very active. The agency is very active, very forthcoming. So the whole structure, friends, is one is the IBBI, the authority. Now, when they created this authority, they understood that it will not be possible for IBBI to execute everything. So they allowed the creation of IPAs, Insolvency Professional Agencies. So these are agencies which will enroll and regulate all the insolvency professionals. And who are insolvency professional? They are the people who will actually execute whatever is mentioned under IBC code. They are the people who will actually be on the ground level, the field work, doing whatever has been asked by the code to be performed by them. So to bring a resolution, the IP, the resolution professional, will be responsible for bringing out a resolution for that particular company by following certain process and mechanism. So how do I regulate those IPs? So IBBI thought, let's create an agency who will regulate all these IPs, enroll them as members, and ask the members to comply with whatever IPA says, monitor the IPs working, and so on. So there are different IPAs. So in India, there are three IPAs. One is ICI IPA, one is ICSI IPA, and third is the ICMAI IPA. So three IPAs are working as of today. So what are the functions? There are three functions. There are three functions: regulatory, executive, and quasi-judicial. So in terms of regulatory, they will devise the code of conduct, the bylaws, which are applicable to all the members. So detailed guidelines are given, detailed bylaws are framed, code of conduct are framed, where each IP, the resolution professional, has to abide by and follow those code of conduct and ensure compliances and reporting to the IPAs. So executive function, they will monitor, inspect, investigate the members on a regular basis whenever they feel they require, and they will capture information with an overall objective of preventing frivolous behavior and ensure there is no malfeasance in the conduct of IP duties, because it's a very critical job and a lot of stake is involved, especially of the creditors, to ensure that the stake, because it is high, they should ensure the proper mechanism should be there to ensure proper flow of information maximization of value, and ensuring that there is no malified intention of the overall process. Then the IPs come into picture. Now, who are IPs? These are individuals like you and me who attain certain qualification and pass an exam, and then you become an insolvency professional, where he will ensure that the work is done in a proper manner, and he is the person who is appointed as the RP of the company, the liquidator of the company, or the bankruptcy trustee. So where we're going to discuss about IP, IRP, RP, liquidator, so that person is that insolvency professional, that individual. So as an IP, I have to abide by the code of conduct, which has been formed by IPA, comply with all the requirements and regulations specified in the bylaws, allow the IPA to inspect his record, to submit the copy of records of every proceeding before the AA to the board as well as to the IPA for which is a member, and to perform his function in such a manner and subject to such condition as may be specified. Then there is an agency known as IU, a very important agency which has been created, and in the last 1 year or so, the agency has become very active, and in times to come, it will play a very important role. And for common people like us, it is also an important agency that is known as information utility. The purpose of this utility is to collect information, collate data, authenticate and disseminate all the financial information of debtors in a centralized electronic database. Okay, now, so what is the purpose? Let's say a bank has given you a loan, has given a loan to a company, and to ensure that that loan is recorded somewhere, though the documents are there, but an authenticity is created to that particular loan, then the bank will give a notice or give an information to IU that I have given a loan to this person. These are the terms and conditions of the loan, and this is the amount of loan. This IU will send a mail or a confirmation to the company that this bank has requested for confirmation. Please confirm whether you have taken a loan or not. And I will have to log on to that site and authenticate, yes, I have taken a loan, and yes, I accept to all the terms and conditions. So now we have created a third agency which is validated from all the parties involved that this transaction has actually taken place. So when we go in the court, there should not be any dispute regarding that particular loan, whether you have taken or not, about amount or terms and condition. There should not be any dispute with respect of this loan. So that is why this information utility has been created. It's an excellent utility. And as an individual, if you have given a loan to anybody, you can also register yourself. Obviously, it has a cost, and then get a confirmation from the other party that you have taken a loan, you have given a loan, and the other party accept that, yes, I have taken a loan. So that will give you an authenticity at every level in the eyes of law. So currently, any SL that's been created by National Stock Exchange that is running this information utility. So the whole purpose is to create the law, and store financial information, accept electronic submissions of financial information, maintain certain quality standards, and so on. From exam perspective, it may not be relevant because it will not come in the exam part. But in general, you should be aware of this IU. What is the purpose of IU? For MCQ part, yes, there could be a possibility of MCQ. Okay, now coming to the adjudicating authority, which we have discussed. The adjudicating authority, what is the purpose? No, it's not related to credit rating. It's altogether a different one. Credit rating will keep a record of all the defaults. Information utility will keep a record of all the transactions which have happened between a lender and a borrower. Irrespective of default or not, that is immaterial. It will not give you any scores. It's a third party validation of the transaction. So adjudicating authority, NCLT, where any case, any application, any legal dispute under this code has to pass through this NCLT. And for individual and partnership, we have the DRT, Debt Recovery Tribunal. And then we have the Appellate Tribunal, NCLT, and DRAT. And thereafter, there's Supreme Court, which means there is one missing element in this whole structure, hierarchy structure. That means there's no role of High Court. So directly from NCLT, we can go to Supreme Court. So which actually gives you certain breather in terms of the time taken to resolve the matter. So XY and company, a firm applied to NCLT to be declared as insolvent. So a firm cannot approach towards NCLT, they can only approach DRT. So this is not valid as per law. Not valid as per law. The whole code is divided into different parts, from part 1 to part 5, covering from section 1 to 255. So that means we have a huge law which has to be studied. 255 sections is not small. It should create a sense of worry in your mind that for a part of, let's say, 6 marks, do I need to go through and review 255 sections? That's a huge cumbersome responsibility being casted on you, along with 12 schedules and plus regulations. There are different regulations for different stages. So that is why it is a very important law, and it gives you a great insight in this world plus good opportunity. But the good part is that out of 255, in our course, we have to study only 20% of this code, because rest of the code has not been notified. Some part, yes, around 40% is notified. Rest 60% is yet to be notified. So 35 to 40% is notified. Even in 35 to 40%, we have to study even less. So that's the comfort which our institute has given to all of us. So we don't need to worry about these 255 sections, and we need to concentrate only on specific areas. So we have the part 1, which is a preliminary part, then section 1 to 3, which will generally apply to all the other parts. Then part 2, which is specific only to corporate person, from section 4 to 77. Part 3 is talking about on individual and partnership from 78 to 187. And thereafter, a lot of section which applies to IPAs, IU, and so on, which is not relevant. And the miscellaneous part, which covers 238 also. So our major concentration will be only on this particular area, and then under this 4 to 77, we don't need to cover the penal provisions and penalty and so on. So that is also ignored. So from section 61 till 77, again, it is not part of our course. And even in the 59, 60, they are also not part of our course, 59, 60, and so on. But we'll just touch upon those specific codes, specific section, just for the knowledge purpose. And as I mentioned, it's about around 4 to 6 questions being asked in the exams, 4 to 6 mark questions. And most of the questions are case-based scenario. So we need to study the provisions and then interpret and study a few case laws also. General applicability is with whole of India. Enforcement date 28 May 2016. Effective date 1/12/2016. Effective date is 1/12/2016. And thereafter, a lot of amendments, a lot of changes have been brought under the law. And many new sections have been incorporated after this law was introduced. Along with these sections, we had the various regulations. For us, our regulations will only be related to regulations with regard to IRP. The rest of the regulations are not material from exam perspective. Applicability as of today, very important to whom it is applied. It applies to companies, it applies to LLP, and very important, it applies to guarantors to the corporate debtor, of the corporate debtor. Now, what does this mean? It means, let's say a company has taken a loan and the directors of the company have given a guarantee to the bank for the loan taken by the company. Or there might be a subsidiary of the company, it might have given a corporate guarantee, or some other company might have given a corporate guarantee. So today, those guarantors are also covered under IBC, which means as an individual, if I have not given any guarantee, IBC is not applicable as on me. To partnership firm, no. So today it only applies to companies, LLP, and guarantors because it was a nascent law. A lot of experimentation is still going on. The infrastructure is still being developed in terms of staff at court and pending cases which are piling up at various court. So if all things become streamlined, probably then only after that it will be applied to individual. Mancha, as of now, it is limited to domestic only, domestic boundaries. Then it does not apply to financial service providers. That means if I want to file a case against bank, take him to court for insolvency, no, you cannot. To ARC, no. Insurance companies, no. Mutual fund, no. Collective investment scheme, no. You are not allowed to file a case against these agencies or service providers. But yes, to NBFC, correct. It applies to NBFC, but it was only introduced in 2018. It got applicable from November 2019, but only to those NBFCs as having an asset size of 500 crore or more. So let us start with the process, the CIRP process, only with respect to corporate. Corporate Insolvency Resolution Process, CIRP process, where we will covering section 4, 5, from 4 to till section 32, along with few regulations from 1 to 40A. So there are 40 regulations and about 28 to 29 sections. Majority of the question will come from this angle only. So let us understand the flow of process. Flow of process. So the flow of process will go in this way. So there will be a trigger point. There will be a trigger point which will actually and indication that yes, that this transaction now falls under IBC, or this particular event now falls under IBC. So once that trigger point is triggered, then we can apply for initiation of insolvency for against any company. And once this application is accepted at NCLT, the moratorium, which is one of the major reasons why company go under insolvency, moratorium will apply. Professionals are appointed as discussed as RP or IRP. And one major committee is formed, that is Committee of Creditors, that is COC is formed. And thereafter the process of resolution plan comes into picture. Until this plan is accepted or rejected, this process will go on. So these are the 6 major steps. This whole CIRP from section 4 to 32 is talking about only these 6 points. Major focus is on these 6 points. So let us understand the trigger point. Trigger point. So the trigger point is where any corporate debtor commits a default. The trigger point is default. Corporate debtor and default. Let us understand these 2 terms. What does corporate debtor means? Corporate debtor means a corporate person who owes a debt to any person. That means a corporate person, which may include a company, LLP, and which owes certain amount to any person. And person means, which is defined again in this act. So the basic criteria is that there should be a default being committed by a corporate debtor towards a person. Towards a person. That is the indirect meaning now. Now, what does default means? Default means a non-payment of debt. We all understand what is a debt. A loan. Now, loan has different structure. A debt is in a different form. It may be in the form of a term loan, a demand loan, or a lease transaction, or a recourse factoring transaction. That is also a form of debt. A guarantee also. So we'll understand the definition of debt also. So when there is non-payment of debt, whether you pay it, do not pay it whole or in part, whatever. If the payment is not made in full, if there's a default on part payment also, it is treated as default. Default when? When it becomes due and payable. So it is due today and it is to be paid today. So when it becomes due and payable, but it is not paid by the debtor or the corporate debtor. Now, why these 2 words, debtor or the corporate debtor? We will focus only on this element. So debtor means individual and partnership also. Right. So, but we will not be covering this debtor. We will be covering only the corporate debtor. So there is a default of debt. So trigger is default of debt. Now debt of what amount? So minimum 1 crore, which became effective after 24th March 2020, just one day prior to the lockdown was announced. This notification was issued, and before 24th March, it was 1 lakh. Before 24th March, it was 1 lakh. And after 24th of March, it was 1 crore. Right? So any questions? Yes, yes. Enforcement date and effective date. Okay. With respect to the law was actually enacted in May 2016, but then it was not notified. So it became notified from 1st December. That means whatever actions which have been taken under this IBC code was only after 1st December 2016. So everything was ready, but it became effective from 1st December 2016. So when I say a default of debt, so what does debt means? Debt is a liability or an obligation in respect of a claim which is due from any person. A claim which is due from any person. So there's a liability and obligation in respect of a claim. So there should be a default of a debt, and debt means there is an obligation with respect to a claim, which can come from any person, and that any person could be a financial creditor and operational creditor. So debt is classified as a financial debt, as an operational debt. So there are two types of debt. As per IBC, they recognize two types of debt. As per accounting, we can classify as a secured, unsecured, whatever. Here, secured, unsecured will fall under the category of financial debt. Though we will redefine again in due course of time, because there's a difference between a secured and unsecured creditor under Section 53. But primarily, we are talking of two debt: financial debt and operational debt. So we're trying to link it, friends. Try to understand. There's a Section 6 which talks about that when this particular code will be triggered, when there's a default. Default is a default of debt. Debt means a liability in respect of a claim. And what does claim means? Claim means right to payment or right to remedy for a breach of contract. So I have linked the various definitions which are given under this code. Definitions under Section 3.6 of a claim. Then 3.6 as debt. 3.12 of default. So looking to definition, what does claim means? Right to payment, right to remedy for a breach of contract. So right to payment, whenever you have supplied any goods, provided any service under a contract, or not even a contract, or against a purchase order or a work order. So you have a right to payment, or you have given a loan under any agreement. You have a right to payment for that particular repayment of loan. So whenever you have a right to payment, any document which proves that you have a right to payment because you have supplied goods, you have supplied services, provided services, or right to remedy for a breach of contract. For example, suppose you have given certain amount to a builder for a purchase of a flat or a plot. But that builder does not delivers you the flat or the plot. So that means you don't have a right to payment because you're not, given any material or supply or provide any service. But because there was a contract between you and the builder that the builder will be providing you that house in 3 years, so there is a breach of contract. And because of that breach of contract, you have a right to remedy. And that right to remedy is giving you a right to payment. There's a remedy attached for a breach of contract, which says that if that builder does not deliver to you, probably he'll repay the amount with extra percentage of interest. So there's a right to payment or any right to remedy for a breach of contract, which will give you a right to payment. Whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, legal, equitable, secured, unsecured, that is immaterial. So whether it has been reduced by any judgment, by any court, it is immaterial. Whether it has got materialized, crystallized to a particular amount, which has become matured or unmatured, which is immaterial. Only criteria is that you should have a right to payment. So remember, default of debt. Debt is an obligation with respect to a claim. And what is a claim? Which we have understood. So debt can be classified under financial or operational debt. And based on that, we will define the types of creditors also. So we have financial creditor, operational creditor, secured creditor, unsecured creditor, and decree holder. Decree holder, which means a person who has got an order from the court for receiving a payment. Maybe there might be certain cases which have been pending, which way you are fighting in a court and the court has given you a decree order that yes, you have a right to receive this amount, and the court is giving you an order to go and recover that amount from that particular party. So that may happen maybe because of an arbitration order, because of a court order. That decree holder is also a creditor. So the major difference is between a financial creditor and an operational creditor. Major. Why that major difference? Because of the section 53 and the COC, Constitutional Committee of Creditors. Yeah, debt section, claim section is 3.6. One check, claim section is 3.6, debt section is 3.11. Yes. Okay, it was mentioned 3.6. Oh. So claim section is 3.6, debt section is 3.11. There is no trigger point in voluntary insolvency, am I right? See, trigger point in voluntary, there is a particular point where I can go for voluntary liquidation. That point is where I should have enough assets to repay my liabilities. The trigger point is there is no default. So when there is no trigger point, so there is an indirect trigger point that there should not be any default. And when you have sufficient assets to pay off the liabilities, then we'll assume that you can go for voluntary liquidation. So that itself is a trigger point. Right? Now, what does financial creditor means? Financial creditor means any person to whom a financial debt is owed, a financial debt, and includes a debt to whom such debt has been legally assigned or transferred. So now we are coming to section 5.7, which actually covers the corporate insolvency process. So any person to whom a financial debt is owed. So we need to understand what is a financial debt. Or it will include any person to whom such debt has been legally assigned. So there may be an assignment of debt. For example, a bank has given loan to a company, But in due course of that time, the bank transfers that loan to some other bank or to some other agency known as ARC. It has assigned that loan. Now, okay, I will not recover the amount. You can take this loan and you can proceed with that particular company. So that process is known as assignment. So when that loan has been assigned to that other company or agency or institution or other bank or ARC, that ARC agency bank will be treated as a financial creditor. Originally, they were not the lenders. The lender was some other bank. So what is a financial debt, which is very important? Now, these definitions, which will come into picture in due course of time when we'll study section 7 and 9, where they'll be referring to this word. So that is why we are discussing these definitions, financial debt. So financial debt means a debt along with interest, if any, which is disbursed against the consideration for time value of money. The essence of financial debt should be a time value of money. There have been a lot of fight which has gone, and ultimately it has been defined that any particular transaction, if it is to be treated as a financial debt, the underlying principle should be there should be a consideration for time value of money. Then only it will be treated as a financial debt. And it includes the following transaction: money borrowed against payment of interest. That is very simple. You have taken a loan, term loan, it will be included. Amount raised by an acceptance of credit facility like CC limit, or to pursuant to any note purchase facility or issue of bonds, notes, debentures, loans, stock, or any similar instrument. If you issued debentures, bonds, or any other similar instrument. Any other transactions, including any forward sale or purchase agreement having the commercial effect of borrowing. Very important. What does this mean? Again, the example of home buyers, flat owners, where they have entered into an agreement that is, I am giving you money today. In view of that, you will give me my flat after 3 years. But what is there? Is there a loan? Have I given you a loan? So the answer is yes. It is treated as a loan because that has an element of interest which is included. So indirectly, there's no loan, but there's having a commercial effect of a borrowing. So that is included under financial debt. And in due course of time, the amendment has come in very clearly, categorically saying that any amount raised from an allottee is defined under RERA Act, under a real estate project shall be deemed to be an amount having the commercial effect of borrowing. So they have included this. Initially, it was not there, but later on they have included in the definition that any amount which is given by the flat owner, homeowner to a builder, that will be treated as a financial debt. Then any liability in respect of any lease or hire purchase as per Indian accounting standards. Any derivative transaction which you have taken to hedge yourself, and because of that there is a borrowing, underlying borrowing which has happened. Any factoring arrangement, because factoring is again a type of a borrowing. Any counter indemnity obligation in respect of a guarantee, indemnity, bond, documentary letter of credit, or any other instrument issued by a bank. We have seen in not many cases. One is the guarantee, the amount of any liability in respect of any guarantee. So company A has taken a loan, and for that loan, company B has given a guarantee. Right. Now, if company A is not able to pay the loan, then obviously company B would be liable. So that liability is treated as a financial debt on company B. Right? I hope the point is clear. Now, and counter indemnity obligation. Counter indemnity obligation is again a third party comes into picture. We say that if B is not able to pay, then I will pay. If B is not able to pay, then I will pay. So that is a counter indemnity obligation. Normally, it is with respect to, let's say, an export transaction where ECGC, if you have heard of the term ECGC, Export Credit Guarantee Commission, it gives a counter indemnity obligation with respect to any transactions entered by an exporter with a foreign buyer. Let's say under a documentary letter of credit. So the bank asks for an counter guarantee from an agency, and ECGC is one agency which provides this counter guarantee. So anyway, not going into further technical part, we need to remember from exam perspective the definition of financial debt. What does financial debt means? It should be very clear. Who is an operational creditor? Obviously, a person who has given an operational debt. Now, what is an operational debt? Means a claim in respect of the provisions of goods or services, including employment. Very important. Please note this. So you have supplied any goods, or as a chartered accountant, you provide any services, or you are working in that company, or a debt in respect of the payment of dues arising under any law for the time in force and payable to CG or state government, local authority. That means what? Income tax, GST, whether it is CGST, SGST, or payment to be made to the municipal corporation, MPB. This will all classify under operational debt. Any questions, friends? Very important. So there are two types of creditors. Two types of creditors: financial creditor and operational creditor. Financial debt and operational debt. Financial debt and operational debt. Now, within this whole framework of creditor, there is further classification of secured creditor, unsecured creditor. And we all understand who is a secured creditor and unsecured creditor. Obviously, secured where we have given certain security asset as a mortgage, then that person is known as a secured creditor. But in technical terms, wherever there is a security interest which is created. Now, what does security interest is? What does this mean? It means we have provided certain security and an interest is created within the security to a bank. That interest may be in the form of right, title, or interest or claim to property by a transaction which will secure the payment or performance of an obligation, which means any mortgage, a charge, hypothecation, assignment, encumbrance, or any other agreement which has been made to ensure that securing that payment. That transaction is creating a security interest. So wherever you find any security interest, then that will be treated as a secured creditor. So the underlying principle to be classified as a secured creditor, that there should be security interest, and this is defined. It is a very important definition because it is very common and it comes under various laws also. SARFAESI Act, it is defined under SARFAESI Act also. So now, after understanding the whole definition, that is section 3, 4, 5, and 6. 6 is the trigger point when there's a default. 4 is the amount of loan, 1 crore, and then the various definition. So what is going to happen if there is a default of more than 1 crore for a financial debt or operational debt, whatever may be the scenario, then what is going to happen? Let us see that. Before, let us solve few MCQ, which is very easy. The motive of enactment of IBC. Motive. So what is the motive? Is it to consolidate and amend all the laws? Is it to maximize the value of asset? Is it to increase the availability of credit? And all of the above. So the obvious answer is, we know that all of the above. Which acts have got repealed on enforcement of IBC? There are only 2 laws which have been repealed. Presidency Town Insolvency Act 909 and CIRP Act 1985. Now, which of the following acts have been amended? So, one of the acts which have been amended out of the 4 given choices, Customs Act. Who is corporate debtor as per the code? Who is corporate debtor as per the code? So the corporate debtor, company who owes a debt to any person, a corporate person who owes debt to any person, a company who borrows from any company, a corporate person who owes a debt to any company. Question is not being amended means. Okay, so it was not being amended. Yes. Okay, so Limitation Act, sorry. Question is not being amended, so Limitation Act is not amended. Sorry. The question was not amended. Limitation Act. So please rectify the answer. Which of the following enactments has not been amended? So Limitation Act has not been amended. So who is the corporate debtor as per the code? So the corporate debtor as per the code is a corporate person who owes a debt to any person. Corporate person who owes a debt to any person. According to the code, which of the following is not a financial service? Not a financial service. So obviously, underwriting and issuance of financial product, it is a financial service. Accepting of deposit, financial service. Operating an investment scheme, financial service. Payment of wages to employees, not a financial service. D. What is meaning of debt under the code? Meaning of debt under the code? Debt means a liability or obligation in respect of a claim which is due from any person. It includes financial debt and operational debt. Both A and B, and none of the above. So as per the definition, it means an obligation in respect of a claim which is due from any person, and it includes a financial debt and operational debt. So that is the definition of debt. So correct answer is C. So let us now go ahead and understand what is the next step once the default happens. So in the world of IBC, we will refer to 3 sections. 7, 9, 10, remember. Yes, Mancha, distress asset. 7, 9, 10. 7, 9, 10. Remember 3 sections, 7, 9, 10. Major section, 7, 9, 10. 7, an application by the financial creditor. 9, application by the operational creditor. And 10, the application by the company itself. 7, 9, 10. Now, what does this mean? So, if there's a default committed by a company towards a financial creditor, then the financial creditor under section 7 will file an application by either itself or jointly with other financial creditors. So if there are 2, 3 financial creditors who have given a loan to a particular company, they can come together, or they can authorize any other person on behalf of the financial creditor. So the question comes in, friends. There are 3 lenders, A, B, C. The default only happens to A. Default only happens to A. Can A, B, C make a joint application? The answer is yes. The law does not say that the default should happen with B or C, then only B and C can join. If there's a default in payment of loan to A, and if A is making an application, then B and C along with A can jointly file. Now, jointly file means what? File what? You have to file an application at the court and ask the court that please, based on this application, the documents, the evidences which I am producing to you, please admit the company corporate debtor into insolvency and let the process of insolvency start. So that is why section 7, 9, 10 are the crux of making an application. These are the first stages, the initial stage after the event is triggered. First, the condition, the event should be triggered. So once the event gets triggered, then you can apply to the court and request the court that please admit the company into insolvency. Now remember one question which is very common. As we have discussed, Are flat owners, home buyers termed as financial creditors? So the answer is yes. They are termed as financial creditors. So as a home buyer, if the builder is not able to deliver to me a home, my flat, can I go and apply at NCLT and take the company into insolvency? So the answer is no. Individually, I cannot go. Law says that if you are a lottee under a real estate project, then you have to come jointly, bring a minimum number of people together, which should not be less than 100 of such allottees under the same real estate project. Now we are talking of a project, not of the company. So if the company has 3 projects, A, B, and C, then if 100 of such people of A project should come together, not of A, B, C together, only of A project should come together, or not less than 10% of such allottees under the same real estate project, whichever is less. For example, if the number of people who have been allotted is less, let's say 50, I cannot gather 100 people. So it should be 10% of the total number of allottees. But under the same project, they should come together, apply at NCLT. So this is an exam question. Now, on behalf of the applicant, let's say in case if it is an guardian can apply. In case of debentures, there's a trustee, so trustees on behalf of the applicant, or any person who has been appointed by the board of directors of the company. So they are the people who can apply on behalf of the applicant. Now, in case of a non-real estate project, there is no such condition. Only condition we have discussed, Janvi, is the amount of default should be 1 crore. That is the basic premise under all the cases, be it a real estate or a non-real estate. Amount should be 1 crore. For a real estate project, if there is a loan given by a bank, then he can stand alone file a case. But it is only in the case of home buyers, they should have a minimum number. Not with respect to the loan which the bank has given to a real estate project. For a non-real estate project, for any other company, there is no such minimum criteria. I hope it is clear, Janu. So when you apply to the court, section 7 says that along with the application, you should submit a record of default. Now, how will I submit a record of default? Obviously, there is an IU. Remember, there is IU, which we can produce as an evidence. See, here there is an IU which has given me a validated document that there was a loan and the company is not able to repay it. Or any other record which you think is an evidence of default, you can file all number of documents. So the application which you see, big applications being carried to the court, that is actually, accumulation of all the documents which you gather and file at the court. So you have to prove there is a debt, there is a default. What do you have to prove? There's a debt, there's a default. If there is a debt, if there is a default, then the case will be admitted, the company will be admitted in insolvency. Then Along with the application, I have to propose a name of the insolvency professional also, who will be appointed as the RP of the company or the IRP of the company. Now, what will NCLT do? Obviously, based on the documents submitted by the corporate debtor, the financial creditor, it will review the application and ascertain the existence of default. It will find whether default has been committed or not. From the records of IU or all the bits of evidence furnished by the financial creditor, and based on that, if there is a default, accordingly order will be passed. If there is no existence of default, the other order will be passed. So the NCLT, after reviewing the application within 14 days from the receipt of an application, which does not happen actually, there's many things which are attached because it's a procedure of the code and a lot of steps have to be taken. It does not happen in a magic that you file an application and suddenly within 14 days you accept that application. Except in few of the cases it has happened, but it never happens, what I've seen from my experience. So the NCLT will give either two orders, either it will admit the application or reject the application. It will admit or reject. And when it will admit that default has occurred, application is complete and no disciplinary proceedings are pending against the proposed interim resolution professional. Or it will reject where NCLT is satisfied that no default has occurred or application is incomplete or any disciplinary proceedings are pending against the RP. Who will carry out the disciplinary proceedings against the RP? IBBI. IBBI will carry out the disciplinary proceedings against the RP. So that is section 7. That is section 7. Now, this was all about financial creditor. Now the question comes of operational creditor. For operational creditor, there are two sections, 8 and 9. Very important. Financial creditor only one, section 7. For operational creditor 2, 8 and 9. What does 8 and 9 says? So 8 and 9 says that before you file an application under section 9 as an operational creditor, you have to take one preliminary step. And that step is basically a transaction or a step which will give evidence that a default has occurred. So on the occurrence of default, when the debt becomes due and the party has not given a payment, occurrence of default, the operational creditor has to deliver a demand notice to a corporate debtor for the unpaid amount, demanding payment of the amount in default in a specified form, Form 3 and Form 4. So it will send a notice. It will say that this is the amount which is due from all my pending bills. Please give me this amount within a period of 10 days. And the company to whom the notice is set, which is termed as corporate debtor, they have to respond in 10 days, either giving the payment or raising a dispute. Not raising a dispute, or mentioning a dispute, not raising a dispute. And mentioning that there is already a dispute which is pending, or any arbitration proceedings are being pending before this notice was received. So therefore, this demand is not accepted. So this is a preliminary step which an operational creditor has to take before actually going to the court. So it's a warning. It's saying that, I'm sending a demand notice, you make a payment, and if you don't make a payment, probably I have to apply to NCLT under Section 9. And then the application comes. So if there is no such response from the CD, either making the payment or raising a point of dispute, not a dispute today, that dispute should have been in existence before. And what does dispute mean? Dispute include a suit or arbitration proceedings. Remember, it's an inclusive definition. That means not necessary that there should be only suit or arbitration. If there is a suit which is pending in the court or any arbitration proceeding, that will be treated as a dispute. But otherwise also, if there is any other document where you can prove that they have already raised a dispute with respect to what? Existence of amount of debt, dispute with respect to quality of goods, dispute with respect to breach of representation or warranty, then that dispute is valid. So if there's no dispute, the operational creditor can file an application. Along with the application, what he has to do, remember, financial creditor has to give a supporting document proving that the amount of default, the amount of debt, and the proof that there's a default. Here, what he has to submit, he has to submit a copy of invoice demanding the payment or demand notice, which he has served prior to the coming to the court. An affidavit to the effect that there is no notice given by the company relating to a dispute. He will say that, yes, I'm giving an affidavit that the company has not raised any dispute with respect to my demand notice, or previously any dispute was raised by the company. That is not there. And a copy from the financial institution that, yes, no payment has been received from that corporate debtor. Even after sending the demand notice, they have not made any payment. Or you can submit a copy of the information utility proving that this had supplied these goods to this particular person, but he has not made the payment. Or any other supporting which will prove the claim of your debt. So what will NCLT do? Yes, obviously the NCLT within 14 days, either it will accept or reject the application. When it will reject, when the application is incomplete, the application has to be filed in Form 1. So the Form 1 is incomplete, or the payment has been made, or the Section 8 compliance has not been done, or if you propose an IRP, then disciplinary proceedings are pending against this IRP, or there's a notice of dispute has been received by the operational creditor, there's a record of dispute in the NIU, there's a record of dispute, then the application will be rejected. or it is going to admit where things are positive in of all these points, it will be admitted. The next and very important, Janvi, your question is the case of the claim which is question should be disputed, like in case a dispute is pending against creditor for similar debt. Though I did not get the question, but I assume that you are asking about a dispute for this debt part. Yes, the dispute should be with respect to that claim amount, that whatever is claiming, not for a dispute for a similar debt, but only with respect to that claim which is making. So application by a corporate debtor. Now you would wonder why a company which has committed a default would go into insolvency. So the provisions, the law has given that facility to a company where they have committed a default and they themselves go and say that I have committed a default, now please admit me in insolvency. So that is allowed under section 10. So 7, 9, 10. 7 by FC, 9 by OC, 10 by the CD itself. So the corporate applicant means the corporate debtor, the company itself goes. A member or a partner of the corporate debtor who is authorized to make an application. An individual who is in charge of the managing the operations and the resources of the corporate debtor, MD, CEO. Or a person who is in the control and supervision over the financial records of the corporate debtor, CFO. So the company itself, a member or partner of the company, or an individual or a person who has the control over the financial operations. They will make an application to the NCLT, provide all the information that there is a default. And along with that, they have to give information relating to books of accounts and other documents, proving that, yes, I have committed a default and this is my state of affairs, my balance sheet. As of today, I'm applying and this is my balance sheet. And along with that, I have a special resolution which has been passed by the shareholders of the CD, which has been passed at least 3/4 of total number of partners of the corporate debtor. So SR, along with statement of affairs or a balance sheet, and a proof of default. So what will NCLT do? Obviously, it is going to admit if everything is complete. So one standard thing, no disciplinary proceedings are pending against the proposed IRP. Now we would wonder why a corporate debtor himself will go. Obviously, when they think that the board think that they are not capable of running the company now, we are not able to pay the debts, there's a huge liability, I cannot do that. So I'll take the company towards insolvency. Let RP take care, let the resolution plan submitted by any other party take care of all the future business of the company. I'm not able to run the company. Section 11 is very important, which is an exception to 7, 9, 10. Which is an exception to 7, 9, 10. So what does 7, 9, 10 says? Sorry, what does section 11 says? That who are not entitled to initiate insolvency process. So a company which is already undergoing an insolvency process, I cannot go and say that please admit me again in insolvency. No. Or the whole process of insolvency has been just completed 12 months preceding the date of making the application. I cannot again go. Or my company is under liquidation. I cannot go and say, please admit me in insolvency. The company is already under liquidation. Or I have been one of the companies which has submitted a resolution plan for some other company. But I violated the terms of resolution plan, which was approved 12 months before the application. Then I'm not eligible. So corporate debtor is not allowed. A financial creditor who has violated the terms of resolution plan. Suppose a financial creditor has given a resolution plan, but he is not able to fulfill the conditions of the resolution plan. He is not allowed. But remember, one explanation which has been brought in, introduced. A company is already under CIRP, that means under insolvency. Now it has to recover certain amounts from some other company. The books of the accounts, their balance sheet shows that that amount is due from B company. Now, can that company, which is already under CIRP, file a case against some other company? The answer is yes. That is allowed. If I want to initiate CIRP process against some other corporate debtor, I should not be stopped only because of the reason that I am under insolvency. No. Even if I am under insolvency, I can file a case against other companies. But if I am under insolvency, I cannot go and file again another case for insolvency against my own. So remember section 11, which is an exception to section 7, 9, and 10. Most probably it more applies to section 10. And the next important part. Can an application which has been made under section 7, 9, or 10 be withdrawn? So let us understand the scenario. I have made an application under section 7 and the case is pending at NCLT. Can I withdraw? The answer is yes. You can withdraw anytime. If the corporate debtor has paid your amount, finish. I don't need to pursue my application and I can request the NCLT that I'm withdrawing my application. Great. Matter over. Very simple. So before the company is admitted into insolvency, can I withdraw my application on my own? Yes. Nobody is going to stop you before the company is admitted into insolvency. But what if the company has been admitted into insolvency by the court and thereafter I want to withdraw on the grounds that I have made a settlement, please, I want to withdraw my application. Then that is also possible, where an application has to be made by the applicant, whoever has given the application under section 7 or 9. But that application can only be made when the COC, which we will discuss later on, has given the consent by giving 90% voting share in favor of withdrawal. In favor of withdrawal. Once the company is admitted towards insolvency and COC has given the permission. But formation of COC takes time. It takes about 30 days to form the COC. What if within that 30 days I want to withdraw? Is it possible? So there are three scenarios. One, the company is not admitted. Nobody is going to stop you to withdraw. The company is admitted, but COC has not been formed. Then by virtue of inherent powers of NCLT, which has been granted to them under Rule 11 of NCLT rules. Rule 11 of NCLT rules, there is an inherent power which has been given to NCLT to decide on certain matters. By virtue of those power, NCLT can allow the withdrawal of the application without having this requirement of 90% voting share, because COC has not been formed yet. As I said, COC takes time to be formed within 30 days of the company admitted into insolvency. But once the COC has been formed, now who will inform the court that the COC has been formed? The RP, resolution professional. He is the person for executing all these things once the company is admitted in insolvency. So once the COC has been formed, then this criteria has to be met of getting a permission of 90% voting share. So section 12A, which talks about this withdrawal. Very important section, friends. Please remember. So section 11, section 12A. Section 11, section 12A. Can I have the answers, please? Who can initiate CIRP? Is it only the FC? Is it only the OC, or is it the CD? All three can initiate, right? C is the correct answer. Which among the following is not entitled to initiate CIRP? We have just discussed section 11. A corporate debtor in respect of whom a liquidation order has been made. It is not entitled. Corporate debtor that has not gone through. Obviously, it is allowed. Financial creditor, it is allowed. Operational creditor, allowed. So, A is the correct answer. What is the time limit, which we have not discussed, which we'll discuss? Where a corporate debtor has committed a default, a corporate application may file an application for initiating CIRP with the adjudicating authority. The adjudicating authority within a period of admit or reject. How many days, which we have discussed, mentioned? 14 days. The adjudicating authority shall communicate the order of admission of application under section 7 to whom? Obviously, to all of the above. A corporate debtor undergoing a CIRP shall not be entitled to make an application to initiate CIRP. Correct. A corporate debtor in respect of whom liquidation order has shall not be entitled to make an application to initiate CIRP. Correct. Both are correct. So before we take a short break, just last one section which talks about the number of days. Section 12 talks about that this whole process, once the CRP is admitted, should be completed within 180 days. And if required, it can be extended by 90 days, that too only once. Once you have to make an application. Extension will be given by NCLT. You have to make an application that please extend this time period by 90 days because there are some things which are pending. We are evaluating the resolution plan, which is better, which is not good. And we need more time to do that. So citing certain reasons, you can extend it by 90 days maximum, but that too only once. You will apply, you will go to the court only once and say, sir, please extend this process by 90 days. And a sub proviso was included or amended, mentioning that compulsorily everything has to be completed within 330 days. Now, why 330? 330 is taken into cognizance of all time spent or lost because of certain litigation. So if there is a time lost within litigation in the court because of certain matters, taking all those consideration, maximum time period is 330 days. So if in exam the question comes is what is the time period to complete this whole process? Answer is 180. What is the total time? 330. So 180, 270, 330. 3 days have been mentioned. 180 is the first timeline. 270 is the second timeline, 330 is the total number of days. That is section 12 under the IBC. Right, friends? So we take a small break so that we can start with the process of insolvency. We move ahead now to the process of insolvency. The process started. Application has been admitted. Now the CRP. Who can file application to extend for that? The RP will file an application at the court on behalf of COC. COC will give the permission. The RP will apply to the court. Please extend the whole period by 90 days. Right, Janvi? Now, once the CRP starts, so the responsibility shifts to the RP now. RP is the key person for this whole process. So we'll understand this process after this short break. I hope there are no further queries. Vansha, I don't understand. I did not understand. We can get 60 days more. Yeah, 60 days more with respect to 270 and 330. Correct. Yes, yes. So CRP starts. Now, what does this mean? CRP starts. So the day where NCLT gives an order, every court will give an order. So it will announce an order that because of these reasons, the company should be admitted towards insolvency. That date is known as the insolvency commencement date. The date on which the NCLT, the court, gives an order. And from that day, the counting, the meter of 180, 270 and 330 will start. And that is the date where we say that CRP starts. Now, what is going to happen when the CRP starts? The NCLT in its order will make three things. It will state three things. Apart from giving all the history, the reasons, it will finally state three things. First, that the IRP is appointed. That means in an exam, if the question asks, who is going to appoint the IRP? The answer is the court. The court is going to announce the name of the IRP. Obviously, the name will be proposed by the applicant under section 7, 9 and 10. So the court may give that name or the court may give any other name. Normally, in most of the cases, it will only give the name which has been proposed. So one, it will appoint an IRP. Second, it will say that the public announcement has to be done. Now, what is a public announcement? Which we'll discuss briefly. And third, moratorium starts. Three things. Public announcement, moratorium, IRP is appointed. So moratorium under section 14 will apply. It says that under section 14, whatever moratorium is mentioned, that will apply. Then it will mention the public announcement has to be made as per section 15 of the IBC code, and the IRP is appointed under section 16 of this code. Great. Now, what does moratorium means? The very important provision of under IBC, which gives certain kind of comfort to the company, the corporate debtor, which has been admitted towards insolvency from certain things. What is that thing? The first thing, it says that if any suit or proceedings are pending against this company, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or any other authority, that will come to a standstill. Any proceedings which are pending, that will come to a standstill. It does not mean it will be withdrawn, but it will be stayed till this CIRP gets completed. That is the first relief which is granted to the corporate debtor, so that the IRP who is appointed will only concentrate on bringing out a resolution rather than involving himself in the various legal issues. So it says that please hold on to all the legal issues, let things get resolved, and then we'll come back to you. Second, it restricts transferring, encumbering, alienating, or disposing of any corporate debt by the corporate debtor any of its asset or any legal right or beneficial interest. That means the corporate debtor cannot sell any of the assets of the company. Or any action which is taken to foreclose, recover, or enforce any security interest by the corporate debt created by the corporate debtor in respect of property, including any surface action. Now, let's say a bank has given a loan, it has got certain security assets against that loan. Now, once the company is admitted towards insolvency, moratorium apply, and moratorium says that the bank cannot take any steps to sell those assets because the company is defaulted. So the bank is trying to recover that amount by selling some of the assets. It cannot do it under any law or under CIRP Act. CIRP Act is one of the acts which provides a recovery mechanism to the bankers. So no banker can take any step. So again, a relief. Recovery of any property by an owner or lessor where such property is occupied by the possession of the corporate debtor. Suppose you have given a property on rent towards the corporate debtor, and the company is admitted towards insolvency. You say that I want to withdraw my place. Please hand over me the possession of that particular place because you're not paying me rent. So I would like to take away my property. You cannot, because moratorium applies and it restricts the person to take any steps for recovery of any property where such property is occupied by the corporate debtor and they are running the business there. So you may not be allowed. That is the benefit of moratorium. If you have taken, the company has taken certain license, permission, grants, the central government does not have a right to withdraw that license. That license is not suspended. Only on the grounds of insolvency. You cannot do that. Yes, it can be done, but when? Suppose CIRP commencement date is 8th June, today. And in coming days, where you have to make certain payment for that license on any right, from 8th June onwards, if it is due for that period, for a period beyond 8th June, not before that. And if you are not making that payment, and because of that payment, if that license is revoked, then it is allowed. But not because you have already made a default on the payment of previous dues and you are admitted towards insolvency, the license is being withdrawn, that is not allowed. Then electricity supply, water supply will not be stopped only because you have been admitted towards insolvency. No. Essential goods will continue to be supplied to you by whichever department they are being supplying. They cannot stop those services. Except if the corporate debtor stops paying the amount for the period after the commencement of insolvency. Then it is the duty of the company to pay that amount, but not for any past use. Very important, friends. People have started taking advantage because of moratorium, and they come to the court and say that moratorium applies even to my personal property. Then this is not allowed. Or a guarantor, he cannot come and say that, moratorium applies to me also as a guarantor. No, it does not. Or any other agreement or arrangement which the government notifies that, yes, in consultation with any financial regulator or any other authority, it decides that this should be exempted from such kind of reliefs or prohibitions, then that will be notified. So moratorium does not apply to individual property or to a surety in a contract of guarantee. The moratorium becomes effective from the date of order. As I said, with the day when the CIRP starts, from that day the moratorium applies and continues till what period of time? Till the completion of the CIRP process, or till the day the company goes into liquidation, whatever. At the end, there could be two things. Either the company will get dissolved or it will be liquidated. So if it gets resolved, till the date it gets resolved, moratorium will apply, or if the company is admitted towards insolvency, liquidation, till that date the moratorium will apply. I hope it is clear the concept of moratorium. Exam related questions, section 14. Very important. One of the prime reasons why company are admitted or company goes towards insolvency by themselves. Section 10, remember, why would company go? Because it feels that yes, moratorium will apply. There will be some relief which will be granted till a resolution comes in. Who shall declare a moratorium? Me, you, IPA, adjudicating authority, IBBI, whom? Remember, it's the adjudicating authority which will declare a moratorium. Which of the following activities shall not be prohibited? So let us understand which shall be prohibited or terminated during moratorium period. Transferring of any asset. It is prohibited. The answer is yes, it is prohibited. Recovery of any property by landowner or lessor. It is prohibited. Any action to foreclose, recover, or any enforce any security interest. It is prohibited. Supply of essential goods or services to corporate debtor. No, it is not prohibited. It has to be supplied. It has to be continued. You cannot restrict that. So correct answer is 2D. Another exam related slide. Appointment of IRP. Appointment of IRP. Very important. So the exam question will be, who appoints the IRP and till what period the IRP holds the office? Till what period the IRP holds the office? So who appoints the IRP? Who can be appointed as IRP and till what period he holds the office? 3 questions. And obviously there are jobs and responsibility of the IRP. So first question, who will appoint the IRP? Answer is adjudicating authority. Second, who will be appointed as the IRP? So the person whose name has been mentioned in the application by the financial creditor or the corporate debtor. Section 7, section 10. Under 7 and 10, it is compulsory to mention the name of the proposed IRP. Very important. Please remember, exam question. Under section 7 and under section 10, it is a condition that the application will be accepted only when the name has been proposed of the IRP. But under section 9, it is a choice given to the operational creditor that they may propose, they may not propose. So if they have proposed, the person will be appointed. But if they have not proposed, then the law says that the A shall make a reference to the board for giving a recommendation of IP who is IRP, and the board will recommend the name. But practically what is happening? A panel is proposed by IBBI, which is given to the respective adjudicating authority within the jurisdiction. And the NCLT will select a name from that panel. NCLT will select the name from the panel instead of writing to the board and getting a reply from the board. So they will select the name from the panel and propose the name. The only condition is no disciplinary proceedings are pending against that IR. Friends, who will appoint? AA. Whose name will be proposed? The name which has been proposed by the FC or the CD under section 7 or 10 or under section 9 by the OC, provided no disciplinary proceedings are pending. But if the OC does not propose a name, then the NCLT will pick up a name from the panel which has been prepared by IBBI and given to the NCLT. From that panel, a proposed IRP will be appointed. I hope the process is clear. So what is the eligibility criteria? Obviously, apart from clearing the exams, who can appear, that is irrespective. But for a company, for a particular CD, who will be appointed? He shall be eligible for appointment as RP for the CIRP if all partners and directors of IPE, of which is a partner, are independent of the corporate debtor. So that means he should be independent of the corporate debtor. Second, he is eligible to be appointed as an independent director on the board of the corporate debtor. When he will be considered as independent? When he is eligible to be appointed as an independent director, he is not a related party of the corporate debtor. Is not a related party of the corporate debtor. And is not an employee or proprietor or a partner of the firm of auditors or secretarial auditors in practice or cost auditors for the corporate in the last 3 financial years. That means if you have been the auditor of the company for the last 3 years, you have employer, the proprietor, or the partner of the firm, you're not allowed. Or if you have been a partner, employee, proprietor, or partner of a legal or consulting firm that has had any transaction with the CD for amount of 5% or more of the gross turnover of such firm in the last 3 financial years, then you are not eligible. So this is an exam slide again, which talks about regulation 3. Then, next question. First, who will appoint? Second, who is eligible to be appointed? Who is appointing authority? NCLT. Who will be appointed? Now your name proposed. What is the eligibility criteria, which we have seen? The next and final question, the period of appointment of the IRP. So the IRP will be appointed till the first COC meeting. Till the first COC meeting. No days have been prescribed. Remember, no days have been prescribed, but it says that he will be appointed till the first COC of the first COC meeting. And the first COC meeting is normally as per the timeline, model timeline, which has been proposed in the rule for regulation 40A of the IBC regulations, where a standard guideline has been given. It mentions that the first COC should be held within 30 days from the insolvency commencement date. That means indirectly the IRP will be appointed till 30th day. Though you don't have to mention that, don't have to directly mention that. First, you have to mention that it will be, he will continue to hold the office till the first COC meeting. And in the first COC meeting, RP will be appointed. RP, resolution professional. From the word interim, the designation changes to word resolution professional. So interim is removed. So designation from interim IRP goes to RP. So the question comes in whether the IRP can be appointed as RP. The question is whether the IRP can be appointed as RP. The answer is yes. The answer is yes. Second question, whether the IRP can be replaced by another RP. The answer is yes. If the COC wants, they can replace the IRP with a new RP. They can propose a name of new RP, or they want to continue with the same IRP, they can continue. It is the choice of COC. That means the power of appointment of RP will be lying with the COC. If they continue with the old IRP, no permission of NCLT is required. But if they change the IRP with a new RP, then they have to file an application under section 22 to get an approval from NCLT. To get an approval from NCLT. So till the time NCLT approves, who will work? So the IRP will continue to work till the NCLT gives the permission. The IRP will continue to work till the NCLT gives the permission. And till 40th day from the commencement of the insolvency process, he will be termed as IRP. Thereafter, he will be termed as RP or deemed RP. His designation will change from IRP to deemed RP or RP. I hope this whole process of appointment of IRP, till what time he will hold the office, is clear. So we'll hold the office till the first COC meeting. In the first COC meeting, the COC may either continue with the same IRP and appoint him as the RP, or they can replace him with another RP. Obviously, that RP will be appointed by the court. Therefore, the COC has to make an application to NCLT for appointment of the new RP. Till that appointment is made, the IRP will continue to function as IRP till 40th day, and after the 40th day, he will perform the duties of RP till the new RP comes into picture. So what is the job of IRP for the 30 days? What he will do? What is the activities which has been defined under the Act that he has to perform? Those 30 days are a very, very crucial element of the whole process, because that's the start of the process. He has to take certain actions. So what happens? The first thing, when the moratorium is declared, the first thing he does is to make a public announcement, which means giving an ad in the newspaper. Within 3 days of the commencement of the CIRP process, within 3 days, he has to come out with an ad in the newspaper in a prescribed format, Form A of public announcement, where he will announce in newspaper, in public, that the company is now under insolvency. And if you have any claim against that company, please file your claims. Please file your claims within X number of days. That is 14 days. Please file your claims within X number of days. That is 14 days. Normally it is 14 days. So he will make a public announcement calling for submission of claims. And when this process of submission of claims goes on, simultaneously, he has to take over the management and the affairs of the corporate debtor. He has to take over the management and the affairs of the corporate debtor, which was being run by the directors and the staff of the company. Does that mean that the staff will resign and stop working, or the management or the directors will resign and stop working? So the answer is no. Then what is the role of the RP? So what happens practically under section 17 and 18 is mentioned, the management of the affairs of the CD shall vest with the IRP from the date of his appointment, where the powers of the board will be suspended. Remember, exam question. Whether the board will be suspended? No. The powers will be suspended. The board will remain there. The directors will be there. The powers of the board will be suspended. That means they will not be exercising any action, take any action on behalf of the company. It is only the RP, IRP who will take all the actions on behalf of the company. And all the officers and the managers of the corporate debtors shall start reporting to IRP and provide access to all the information, documents, records of the CD as and when required by the IRP. And thereafter, the instructions will be given to the financial institution where the bank account is being maintained of the corporate debtor, and he will give an instruction that now onwards, the bank account will be operated only on the instructions of the IRP rather than anybody else. And he can request from the institution to provide any such information, account statement from the financial institution. So this is the power of IRP. So once he comes to reaction, because he has to take over the management and the affairs of the corporate debtor, what he will do? He will act and execute in the name of the corporate debtor all documents. He will have authority to access to any electronic records of the corporate debtor from information utility having financial information of the corporate debtor, including that. And he has got the authority to access to the books of accounts, records, and other related documents of the corporate debtor available with government authorities, statutory auditors, accountants, and such other persons. Whatever information they have got, they have to provide this power documents to the IRP. And then he has to ensure all the compliances of the corporate debtor. Very important. He has to comply with all the requirements under any law for the corporate debtor. So these are the powers along with the responsibility, obligation. So that is one job with respect to the corporate debtor. He has to ensure the company runs as a going concern. If the company is running, operations are going on, production is going on, services are being provided, he has to ensure that all things continue to perform, produce, provide services. There should not be any breakdown, breakage, stop, halt of the operations. Therefore, he has been given with so many powers. So that is one aspect, managing the affairs. The other aspect is to collate information. He has to understand the business operation for the previous 2 years. Then he has to get the list of assets and liabilities as on the initiation date. He has to get hold of all the financial and operational payment for the previous 2 years, so that he can take certain steps, which we'll discuss later on. Why these are required for those 2 years. But very important, he has to, take the list of assets and liabilities. He has to know what are the assets so that he can take control over these assets. So he can take control and custody of any asset. So which are the exam question, which are the assets he can have control? So the list of assets are given. Assets over which the CD has ownership rights, whether located in country or outside. Assets which are not in possession of the corporate debtor. Tangible, intangible assets, everything. Any securities, including shares held in subsidiary of the corporate debtor, financial instruments, insurance policies. But assets will not include, very important exam question. Assets will not include those assets which are owned by third party but are in the possession of the corporate debtor, or assets of any Indian or foreign subsidiary, or any assets notified by the government. That's very natural. So again, going back to the duties of IRP. What is going to do? Public announcement, first step. Call for the claims, second step. Management of affairs of CD. Review of financial statement of CD, that we have seen now. But what is he going to do with the claims? He has called for the claims. The claim has been received. What next? So friends, whatever claims which he has received, he will consolidate all the claims and verify those claims, whether that claims are correct or not, whether that amount has to be paid by the corporate debtor or not, whether that is actual or not, whether all the documents which are required to substantiate that claim has been submitted by the claimants, the creditors, be it operational, financial, government departments, employees, workmen, secured creditor, unsecured creditor, whoever wants to file a claim. So he will consolidate and verify all those claims. Great. So that is one job, verification of claim. Taking over the assets. Second job. Getting the information for the last 2 years. Third job. So 3 main jobs. Fourth, management of affairs. So management of affairs, taking over the assets, calling for information from various sources, and then calling for claims, consolidating and verifying the claims. So 4 prime jobs of IRP, and he has to do all these jobs within 30 days. Within that 30 days, he has to perform all these jobs. Now, claims and received, he has verified. What next? It's not an easy process. He has to verify claims. He has to reply to all the claimants, whether there's any shortfall in the document, any further information which is required. He has to continuously be in touch with these claimants. So the one simple question which would come into your mind, sir, what happens if I'm not able to file the claim within 14 days? As a person, let's say as an individual, I am a creditor, I have supplied certain service, provided services or supplied material. I am not aware of any public announcement in newspaper. He might have given a public announcement in any of the newspaper. I do not read those newspaper. How will I come to know about this process? I have not received any letter from the IRP also. So does the IRP has to send letters to all the creditors? The answer is yes. If he has got the information, he should send. But if he has not got the information, obviously he will not be able to send. Who will provide the information? Suspended directors. But IRP has got the right to access to the information. What happens? The suspended directors do not provide access. They tell, no, I'm not going to provide access. You come, you do whatever you want. They do not give you any access to the tally data or software data, whatever accounting software they have used. So in that case, there's a dispute or there's a provision. But then primarily we understand that yes, if that information is not received to any creditor about the commencement of CIRP as an individual, I am not able to file my claim. But let's say after 45 days, I come to know about the company is into CIRP and I have to file a claim for my old amount. What should I do now? Can I go and approach the IRP that file a claim? The answer is yes, you can go. You can approach the IRP or the RP and say that I missed out. I want to file my claim. So practically, I'll give you the scenario. Theoretically, you have to file a claim within 40 days. And theoretically, in the law, it has been given that maximum time period is 90 days. So within 90 days, if you are able to file it, good enough. You can file it. The RP will not reject your claim. What after 90 days? Is my claim, I lose the right of submitting my claim? So even after 90 days, if the RP takes on the claims, if he continues to accept the claims, the RP can do it. But if the RP says, no, I will go by the law, I will not accept your claim. If you want to file a claim and you go to the court and then get a court order, then I'll accept your claim. So that means then after that, you have to approach NCLT and request the NCLT to give directions to the RP to accept your claim. So if in exam question, what will happen to your claim? First 14 days, thereafter 90 days, beyond 90 days, approach through NCLT and file a claim. What will happen to a claim? The claim will be collated and verified and accepted, admitted by the IRP. Collated, verified and accepted. He should do three things: collate, verify and accept. What if he accepts an X amount and you have claimed a Y amount? Either you argue with the RP and convince him, and if he's not able to get convinced, approach the court and ask him to convince. You fight out at the court and ask him to convince and give directions to the court and fight in the court and say that this is my claim amount. Janvi, there is no such provision of more than one IP. IP will only be one. Remember, if the company is large, IP just takes over the job of a CEO or the managing director. Rest, all the people will keep on working. So, along with himself, he can bring his own team. He can bring his own support team. He can appoint few people along with himself to carry on this process of IRP. CIRP. That is allowed under law. So three questions, very important. Function of IRP, period of appointment of IRP, who will appoint IRP, and claims, submission of claims, public announcement, and so on. So I hope things are clear till now. Any questions? Another question which can be asked is how the RP is appointed. So RP is appointed in the first COC meeting. As IRP is appointed till first COC meeting, the RP is appointed in the first COC meeting. Can the old IRP be appointed as RP? The answer is yes. So the old IRP can be appointed as RP subject to the consent of COC. Or the COC, if they can propose and replace the old IRP with a new RP, provided a consent has been taken from the new RP. But then that appointment is subject to approval of NCLT. So an application has to be made by the COC to the NCLT for appointment of the new RP. Is it clear? And can you tell me, you can ask me, sir, can the new RP who is appointed, can he be replaced anytime? So yes, the new RP can also be replaced under section 27 anytime. by voting by the COC of more than 66%, and they can appoint any other person as the RP. So that means from this whole understanding, what we understand that COC is a center where everything will revolve. For every permission, I have to go to the COC. So let's answer a few questions. Just 1 second. Yeah. So Mr. Z was continuing as IRP in XY and Company Limited. The COC by majority of 75% of the financial creditors proposed to appoint Mr. Final as RP. The said proposal was confirmed by IBBI after the expiry of 10 days. State whether Mr. Final can be appointed as RP immediately. The answer is no. He cannot be appointed as RP till the appointment is made by the NCLT. So till that time, it is Mr. Z who is going to continue. Even if IBBI has confirmed, but appointment has to be done by NCLT. Perfect Polyester Limited is undergoing CIRP process. The COC is constituted. In the meantime, as corporate debtor, Perfect Polyester made a settlement with the applicant, financial creditor, and desires to get the application withdrawn. Seeks your advice. Can the application be withdrawn? The answer is yes. How? Application has to be made by the applicant. In the application, he has to say that I'm going to withdraw along with what? A voting result where it mentions that 90% of the COC, because COC has been constituted, has agreed to this withdrawal. Therefore, please withdraw this application, and thereafter the application will be withdrawn. So we have understood the role of the IRP, public announcement, the appointment of the IRP, the RP, and so on. So what is going to happen once the RP is appointed? So the job of RP is to what? We have seen the job of IRP. The job of the RP will be same as IRP. He has to ensure the company runs as a member going concern. He will continue to execute deeds, take over the assets, monitor the assets, and take custody of the assets, and so on. In addition to that, his major job is to bring out the resolution. And submit the resolution plan to the COC for their approval, and thereafter to adjudicating authority for their approval, if approved by COC. That means now the shift from managing the affairs of the CD goes towards the resolution of the CD. So once things stabilizes, now the law says now focus on resolution. So the RP's major role is to bring out a resolution by following the steps. In the meanwhile, the old IRP, if he has been changed by a new RP, he will hand over all the information to the RP. And the RP will take immediate custody and control, represent on behalf of the corporate debtor. And very important, three things which are important to the whole process. Obviously, once he has taken custody, will ensure, preserve and protect the assets of the CD. If the custody has been transferred to the RP, he will ensure the preservation and protection. He can appoint any accountant, legal professionals for his support. But now the major job, as I said, is to bring out a resolution. When I say resolution, that means he has to invite applications from people to submit a resolution plan. How is he going to invite? Obviously, he has to make a public announcement. So he will invite the prospective resolution applicant, RA, to submit a RP resolution plan. So he will give an ad in the newspaper known as expression of interest, EOI, under form G, and ask people that these are the basic details of the company. These are the conditions, that these are the eligibility condition, that who can apply, who can make an application for putting up a resolution plan. Obviously, all those conditions will be approval of subject to approval of COC. Approved by COC, then only it will be placed, put on the ad. And he will prepare certain documents which should be given, which will be given to the prospective buyers. That document is known as information memorandum, along with all the details of the corporate debtor. Whatever the prospective buyers want, they will call for all the information. And during this whole process, he can keep on calling and convening all the meetings of the COC. And if during this process time period he will receive certain claims, he will prepare an updated list of claims. And this is another job on the right hand side corner, which will come at different point of time. Filing of avoidance, application of avoidance of transaction, which we will discuss at last. This will come under different sections. So please keep this in mind. And remember this as an exclusive section. So whenever I refer to as an exclusive section, remember I'm talking about avoidance of transaction. Exclusive section, avoidance of transaction. Now, after understanding the RP job, when I say he has to accept he has to call for resolution plan. So there's a process of calling, submitting it to the COC for the approval. COC will approve, thereafter he will give it to the A. But now let us understand the major role, that is of the COC. Then we'll refer to the question. So in exams, few questions are asked on COC. So first, let us understand who are the people who will comprise this COC. Who are the people who will comprise this COC? The COC shall be formed with financial creditors only. Exam related question. Only FCs, only financial creditors. Second, financial creditors who are related parties will not be part of this COC. Neither they will have any right of representation, participation, or voting in the meeting of COC. But if that party has become related by virtue of any transaction which has happened only on the account of conversion of debt into equity shares, then that will not be treated as a related party. There have been cases where a banker has converted that loan into equity because the company has defaulted on loan, so they decided to convert that loan into equity before the commencement of insolvency process. By virtue of this transaction, we cannot say that bank is now a related party, so therefore he should not be part of the COC. No, wrong. So exam related point. This is an exception to the transactions which can classify them as a related party. Now here it does not mean financial only secured. Even unsecured financial creditor will be part of COC. Secured and unsecured, unrelated will be part of the COC. And that relative definition has been given. I'm not going to details of that relative definition, which is very exhaustive. And we know that all these relative definitions, be it under income tax, be it under Companies Act, be it under IBC or any other act, they are not same. I don't know why, but our relatives change as per the law. So very difficult to learn all those relative definitions because it's a huge, vast. But one thing which I find very interesting, friends, and we should believe that though we have relatives have been defined, in practical terms, we also find that there are friends who are more closer to us than the relatives at times, who know more of us than our family members at times. Those who are part of our daily life, day in, day out. And surprisingly, they are never part of relatives. And that's a good part. Anyway, so let us understand the structure of the COC and the complications involved. First definition, only FCs are part of COC. Be it secured, unsecured, it is immaterial. Related parties are not part of the COC. They do not have right of representation, voting right, participation. Very clear. They will never come to the meetings of the COC. Now, sir, can you tell us what is going to happen if there are no financial creditors? Or can you tell us what if all financial creditors are related? What is going to happen in that case? So friends, in that case, remember, if there are no financial creditors, the regulation 16 says that the COC will be constituted of all operational creditors consisting of 18 in numbers by value, one representative by workmen, one representative by employees. So there will be 18 operational creditors by value, one employee, one workman under regulation 16 when there are no financial creditors or all financial creditors are related. And remember, the voting rights of each of the members of the COC will be in proportion of the debt due to such creditors and as accepted by the RP. So based on that debt which is accepted and total debt, the percentage is calculated and the voting right will be based on the percentage. So that is about constitution of COC, friends. So that's all for today's discussion, where we have done a lot of concepts. We had a lot of concepts, new things. I hope there is some new value addition for today's class for all of you. And we'll continue from day after tomorrow further on COC, authorized representatives, rights of COC, the powers of COC, and thereafter we'll move on to the process of a resolution plan, acceptance of resolution plan, and so on. So any further questions? Any doubts, any query? If you have, please raise it. No? No questions? No. Right. So thank you. And then see you soon on Saturday with the rest of the concepts of insolvency. Okay, Jan. Thank you.